So, welcome everyone. I'm Susan Greenblatt. I'm the executive director here at Good Life. And today we have Tina Annis from Annis and Zellers. They are our partners of the month. So we want to thank them for supporting us for the month of October and every year. Tina has been great to work with, does presentations with us throughout the year at Good Life, and just has lots of information to share with you all today. So I'm gonna give it over to Tina and let her get started.
Great, thanks so much. Thanks for coming out. It feels like summer today, doesn't it? Not really. Mid-October is kind of weird, but I'm happy to get out. I don't know about you, but I don't get out a lot these days. So this is a big outing for me. So I really appreciate you all being here. Just to give you a little bit of background about myself. So I am an attorney here in Concord. My office is located right on the corner of Pleasant Street and South State Street. We have a nice blue sign out there on the corner. I've been practicing law for over 20 years, and I've always practiced in this area. So I prepare wills, trusts, powers of attorney. I do probate work. I help administer trusts and estates. I do some Medicaid planning, and when I'm forced to, I do some tax work. I'm a mom. I'm a New Hampshire native, grew up here. Any other New Hampshire natives? Oh, cool. Yeah, New Hampshire native. I have two kids. My daughter is 19 going on 45. She's a sophomore in college in Rhode Island. And my son is 17 and he's a junior at Concord High School this year. So I have a little dog. Anybody else get a dog during the pandemic? Oh yeah, pandemic puppies, right? Yeah. I'm a little traumatized to be away from her because I actually bring her to work with me every day now. So it feels a little weird not to have her here. Maybe next time I can bring her if people are amenable to that. But that's a little bit about me. The topic today is one that I love to discuss. It is the top 10 questions about estate planning. So over my 20 years of practice, I've developed this list. These are literally the most common questions that I get asked. Today is really just an overview. We only have an hour, so some of it is going to be sort of high-level overview stuff. Keep your eyes peeled for some more detailed presentations I've got coming up in November and December. I'll go over those too if you want to get a more in-depth view on some of these topics. But today is the top 10 questions, and in your packets, you should have the list of questions. The 10 questions are right there in front of you. The rest of those are articles that you should not read today, because if you read them today, you won't hear what I'm saying. So take them home, read them at home. It will be a review of the things that we're going to talk about today. I'm going to save questions to the end because of the format here. So these are the top 10 questions. So you may find if you actually wait, you may find that your question is answered. But when we get to the end, I will leave some time for questions, both on Zoom. Welcome people on Zoom and the people who are here. Okay. If I'm not loud enough, please let me know. I've never had that be a problem. I tend to get louder as time goes on, but certainly if that happens, it's different with the mask. So let me know if you can't hear something. Sound good? Okay. So question number one on our top 10 list, what is estate planning? People, I think, are frightened by that phrase. Like, I am not a millionaire. I don't need an estate plan. If you have a checkbook and friends or family, you need an estate plan. That covers basically everyone. And that is really what I believe, is that everyone needs an estate plan, regardless of your age, regardless of your finances, regardless of your family situation. Estate planning defined is the process of planning for the possibility of your incapacity and for the eventuality of your death, with legal documents that will direct people how you want things to go. That's what estate planning is about. So let's just take a little informal poll, and people on Zoom play along as well, if you will. So show of hands, don't be shy, no judgment. Who has a will? Pretty good. Now everybody who doesn't have their hands up, keep your hands up, and then everybody else put your hands up too. Because it was a trick question. Because the fact of the matter is, everybody has a will. The question is simply who wrote the will. Because if you did not write your own will, then the New Hampshire legislature has written one for you. That's a fact. So what I'm referring to is the New Hampshire intestacy law. The New Hampshire intestacy law is the law in New Hampshire that says, if a person doesn't have a will, we have decided where their assets are going to go, and this is what it says. And sometimes that surprises people as to what the legislature decided. I mean, we have a fine legislature here in New Hampshire. However, I personally would rather write my own will than have the legislature write one for me. I'll give you a quick story of a case where this bit sort of came back to haunt somebody. I had two sisters come to see me. Their brother had died somewhat unexpectedly. And they came to see me and I said, well, did your brother have a will? And they said, oh, well, no, he didn't. However, we spent a lot of time talking about it. We know exactly what he wants. And I said, okay, but are your parents living? And they said, well, yes, they are, but we are estranged. My brother had not talked to them in over 10 years. He didn't want to have anything to do with them. We don't even know where they're located. Well, I had to deliver the bad news that in a case like this, where this gentleman died without a spouse, without children, his parents were set to inherit his assets under the New Hampshire intestacy law because he didn't have a will. And we had to hire a search firm and go find his parents and then deliver the inheritance to them at the end of the day. Everyone was very disappointed. But if you don't write your own will, the legislature writes one for you. So important to understand, in my view, estate planning is about taking control. Okay, because any of these scenarios that could happen to you, incapacity or death, the law provides an answer for how to deal with these issues. Estate planning lets you decide rather than the law. You pick the people, you pick the how, you pick the where, the when, rather than relying on what the law says. So that's what estate planning is. It's taking control, creating legal documents to say what you want to have happen. Got it? Question 2. Okay, Tina, that sounds great. I need an estate plan. I'm convinced. How do I do it? How do you have an estate plan? 5 steps, okay? Step number 1, get organized. This is a really important step. As we go through our lives, we kind of sometimes lose track. I've got an account over here. I've got an investment over here. Didn't I have life insurance at one time? I don't know. You have to gather up all of your information. What are your assets? What are your liabilities? There is a sheet that I want you to read when you get home, not now, in your folder that talks about what it means to have your affairs in order. There's a little sort of checklist there about the kinds of things that you need to know to get yourself organized to start thinking about your estate plan. Step 2, figure out how your assets are titled. This is part of getting organized, but it's super important when it comes to estate planning. It's not enough to say, yeah, I own some land over there in Maine. You need to find yourself a copy of the deed and look at it, because your memory is not necessarily going to be accurate about what the deed says, whose name is on the deed. The same is true for bank accounts, investment accounts, life insurance policies. You have to collect those documents, figure out who the owner is, and understand what you've got before you start making plans. Okay? Step number 3, develop your goals. So this is where you take some time to think about, what do you want to have happen? In particular, who do you want to put in charge of various things? If you are not able to make your own healthcare decisions, who should be in charge of that? If you need some assistance handling your finances, who do you want to put in charge of that? After your death, who do you want to put in charge of handling your remaining bills and distributing the assets to your ultimate heirs? You have to think through who you want to put in charge, because if you don't, it's whoever volunteers. And so again, it's that control piece. Thinking about, nobody likes to think about their mortality, but there's nothing like a pandemic to sort of force us all to do that. What do you want to have happen? What's your legacy? Who do you want to leave assets to? What charities are meaningful to you? Those are the kinds of things in developing your goals you want to think about. So 5 steps, we were on that was step number 3. Step number 4, you guys are going to love this one. Step number 4, see your friendly neighborhood lawyer. Okay. Is it possible to do an estate plan without a lawyer? Yes. Is it a mistake? Huge. Why? Because if estate planning was very simple enough for everybody to do, I would not be fully employed. Okay. So you can go to Staples and find a will in a box. You can go online and find forms, but it's very dangerous to do that. And I'll tell you why. One reason is because the forms that we're talking about when you build an estate plan are very state specific. The New Hampshire law is not the same as Massachusetts law and California law and Florida law. They're all different. It's one of the gifts of living in the United States of America, as we have multiple levels of laws. And so if you are getting something from a box or online, you have no idea what that means for New Hampshire law. So you have to be really careful about those sources. Number two, you have no idea if the forms that you're looking at are up to date. For example, I know, because I do this, that the New Hampshire Advanced Directive for Healthcare was updated in July of 2021. If you went online, I bet you would find many versions of the old form, but how would you know whether it was current? Finally, I will tell you what I always tell my kids. I can't imagine signing a legal document that you don't understand. So getting a document from Staples in a box or signing something online does not give you the benefit of having a professional who knows what those words mean to help you understand what the words mean so that you know what you're doing when you're signing the document, okay? So I will get off my soapbox now, but step number 4, see your friendly neighborhood lawyer, okay? Step number 5 for how to construct an estate plan, document the plan. That's the part I help people with every day. People talk to me about their goals and their family and their hopes and what they're looking for. We put together some legal documents that I know work, and we sign things, and now you've got yourself an estate plan, okay? Question number 3 on our top 10 list. Okay, what documents are part of an estate plan? Well, really there are, I would say 4, it depends on every person's particular situation, can be a little bit different, but the 4 basic documents are, number 1, the New Hampshire Advanced Directive. That's one I mentioned already. That is a healthcare form. That is the one that was just updated in July of this year. That is the form which allows you to name somebody else to make medical decisions for you if you become unable to make decisions for yourself. It also contains the living will, which allows you to give your family some guidance about when you might want to be removed from certain forms of life-sustaining treatment, like life support, artificial nutrition and hydration, things like that. So that's the first document. The second one is the durable power of attorney for finances. So these are documents that apply while you are still living, whether it's healthcare or financial, but those are 2 separate documents. Your healthcare is taken care of in the New Hampshire Advanced Directive. The financial piece is in the durable power of attorney for finances. That document was revised in 2018 in New Hampshire. So if you have a pre-2018 financial durable power of attorney, you should consider an update because the law changed. The durable power of attorney for finances lets you select another person, we call them your financial agent, to manage financial tasks for you. So they could do anything from paying your bills to filing your taxes to filling out loan applications, selling your house, anything you can do with your assets and financially, that's what you're appointing another person to do. And the absence of a power of attorney, whether it's for healthcare or finances, often results in guardianship. So remember at the beginning, I said, if you don't have an estate plan, the law has one for you. That is the alternative to powers of attorney, is guardianship. Guardianship happens in a court with lawyers and hearings and paperwork and filing fees. Powers of attorney and advanced directives are fairly simple legal documents that you sign privately in advance to keep everybody out of court. That's why we do them. So I said there were 4 documents for most estate plans. So the advanced directive is one, the durable power of attorney for finances is another. The will is sort of the traditional document that people think about when they think about estate planning, I assume. And the will is your opportunity to name an executor, which is the fancy legal word for person who's in charge of your estate after death. It allows you to, if you have minor children, you can name guardians for your minor children. And it allows you to direct where your assets should go at death. That's the basics of a will. A trust is another really common document in New Hampshire in particular. And I'm going to go into quite a bit more about what a trust is and how it works and why it might be good. But I would say at least 95% of the clients who come to see me decide to include a trust as part of their estate plan. Really incredibly common here in New Hampshire, okay? So we are up to question number 4 of our top 10 list. Question number 4 is, what is probate? This is a really important question because it very much drives how people construct their estate plans. Probate is a court-supervised process for getting a decedent's assets to where they belong after the person has died. In a nutshell, that's what probate is. Probate is different in different states. We talked about this a little bit already, but this is one of those areas where the law is significantly different in New Hampshire. Oh boy, we got noise. So let me know if you can't hear me. Probate is very different in New Hampshire versus Massachusetts versus California and so on. We in New Hampshire are known to be a little bit unlucky when it comes to our probate. Has anybody here ever served as the executor of a New Hampshire probate estate? Anybody? You have. Did you love it?
I had help.
She had help. You had a lawyer. What was there anything about the process that you found negative or difficult? No, good. I'm glad to hear that. How long did it take?
Less than a year,
Less than a year, but more than 6 months?
maybe not even.
Well, it has to last 6 months. New Hampshire, there's a rule for that. So somewhere between 6 months and a year. Okay. So that's typical in New Hampshire and is the first important thing to understand about probate in New Hampshire. There is a rule in New Hampshire that says a probate case has to stay open and in place for a minimum of 6 months. And so that is intended to give creditors enough time to come forward and say, hey, the decedent owed me money, right? So we leave the estate open to give people time to do that. Many, many, many estates take longer than 6 months. If there's real estate to be sold, if there are a lot of creditors, who knows? So a year is a very common time frame for a probate case in New Hampshire, 6 months to a year. And when you think through what that means, it means from the time the person has died until the time the heirs actually receive their inheritance, very often an entire year has gone by. And many people feel that that is too slow. That seems like a lot of time to go by when you're trying to transfer assets to heirs. The other unique thing about New Hampshire probate is that it involves quite a bit more paperwork than many other states. And very often people hire a lawyer to help them with the probate process. It is not intuitive. It is not uncommon for people to need legal assistance. Your executor is likely going to want to hire a lawyer to help them fill out the paperwork and get it filed correctly, because it isn't going to make sense to someone who doesn't do it every day. So that's sort of another strike that I hear people tell me about probate. It takes too long. It costs too much because lawyers are expensive and most of them charge hourly. And if you charge hourly to do work for 6 months to a year, that tends to add up. So it can get expensive, even for simple estates. Now, a lot of people say, well, if I have a will, doesn't that avoid probate? No. Having a will is part of probate. Probate includes presenting the will to the judge, asking the judge to approve the will, and then the judge will supervise the carrying out of the will. Having a will absolutely in New Hampshire does not avoid probate, okay? So one other sort of unique aspect of New Hampshire probate is the bond requirement. And so in the vast majority of probate cases in New Hampshire, the executor is going to have a bond. And so remember what I said, the executor is the person that you nominate in your will to be in charge of your estate. The first thing to know is that that is a nomination. It is not a guarantee. If you nominate someone to be an executor in your will, they are not in fact the executor until the court approves them, okay? And one of the things that the court will require before approval is that the executor obtain a bond. A bond is an insurance policy, which is designed to reimburse the estate if the executor does something they're not supposed to. And New Hampshire is unique and very strict about this. And the reason that we are is because of a case that happened before I was even a lawyer. It was the Judge Fairbanks case. Anybody heard of Judge Fairbanks? Couple hands. Judge Fairbanks was not fair as a judge. He was actually accused and found guilty of stealing from a number of estates. And by the time they figured out that this had happened, the money was gone. And so all of these innocent beneficiaries were left without their inheritance. And so from that day forward, judges in New Hampshire said, we cannot let this happen to people. We are therefore going to require someone who is an executor to carry a bond, which will reimburse the estate with the money if something goes awry. So we're stuck with that. But the problem is that when an executor applies to an insurance company to get a bond, they're not always granted. So the insurance company only wants to insure people with impeccable credit, without significant debt of their own, and without any sort of disharmony in terms of relationship with the other family members. So the bond application is going to ask some pretty detailed questions of this executor, and the bond company may or may not say yes. If the executor can't get a bond, then the executor cannot serve. So it's just a quirk of New Hampshire law that people need to be aware of. Nominate an executor if you're going to use only a will, that will be able to get a bond. So we spend a lot of time talking to people about avoiding probate. I see a lot of folks who come in to see me and say, hey, I had to do this estate for a relative of mine and it took too long. It was too expensive. There was this nonsense with the bond. It was too much paperwork. I had to talk to a lawyer for a year. I didn't like it. What do? How do I avoid probate so that my family does not have to do this when something happens to me? Well, the simplest answer to that question is a trust. And so I mentioned before a trust. I mentioned before that a very large percentage of people who do estate planning in New Hampshire make use of trusts. And this is why. Because a trust is a very easy way to avoid probate. So we'll circle back to that and how it works, but I want to talk about trusts so we can get a little bit into the mechanics of what a trust is, how it works, and why some people find it to be beneficial. So that's question 5 on our top 10 list. What is a trust, and do I need one? I think the easiest way to begin a conversation about a trust is to understand that a trust is a private contract that you enter into with yourself, which makes it pretty low risk, right? We don't mind entering into a contract with ourselves. And to demonstrate this, I would love to have a volunteer who's here. And who would be my volunteer? Would you be my volunteer? What is your name?
Lou.
Lou. Thank you, Lou, for being my volunteer. So let's say that Lou came to see me and Lou is interested in a trust. And so if Lou was going to create a trust, first thing to know would be to understand some of the language around trusts. So when we talk about contracts, we talk about parties who sign on to the contract, right? Who's signing this contract? So when we talk about a trust, there are 3 parties that sign on to a trust contract. The first one is the grantor, and that's a fancy legal word for person who creates a trust, okay? In our case, Lou. Lou is the grantor, all right? The second party to the contract is the trustee. That's a fancy legal word for person who's in charge of the trust. That would be Lou, would be our trustee, okay? Third party to the contract is the beneficiary. That word means pretty much what you think it does. In this context, person who benefits from the trust. You want to guess who that is? Lou is the beneficiary. So when we talk about creating a trust where you're signing a contract with yourself, it's because Lou, with her trust, is the grantor and the trustee and the beneficiary. So she's the one in control. She's the one who signs this trust document. She directs what happens in every case. So people are comfortable with that because it provides a lot of flexibility and control. The second piece of language that's important to understand when talking about trusts is revocable versus irrevocable. The vast majority of trusts that you see are going to be revocable trusts. Revocable means you can change your mind about what the contract says. Okay, so we write this trust contract. Lou has a trust contract. And 5 years from now, she changes her mind about something. She has the power to do that. She can do an amendment to her trust. If she gets sick and tired of having a trust, she can get rid of it entirely. A revocable trust is never set in stone, is always pretty easy to amend and change. An irrevocable trust, you can probably guess now, cannot be changed. Once you write that contract, it says what it says, and you're not changing it. Now, we are lawyers, so there are always exceptions to these things, but you cannot change it easily, okay? And so you would never want to enter into an irrevocable trust contract without very good reason to do it, because life changes. We know that now more than ever. You don't want to be locked into a contract that you can't change. So they're much more specialized. People will sometimes do them for asset protection planning, which we will talk about, and I don't agree with doing it. Or people will use it for tax planning if you've got, maybe $20 million or more, okay? Otherwise, revocable trust. So I talk about a trust as a contract because it is, and because I think it helps us to wrap our heads around the concept because we've all experienced contracts in our lives. But to be honest, it is a little oversimplified to say that a trust is just a contract, because it's actually more than just a contract. A trust is also an entity. So you are probably aware of entities like corporations and LLCs, right? Head nods, yes. So corporations and LLCs can own things, can't they? Like a corporation can own a building, an LLC can own a bank account. A trust can do that too. And that's the point. So if Lou was to create a trust for herself, she would also want to then fund the trust. Funding the trust means allowing this trust entity to own Lou's assets. So if Lou owns bank accounts, she could transfer those bank accounts so that they were owned not by her, but by her trust. If she owns real estate, she could transfer that real estate so that it was owned not by her, but by her trust. She could do the same thing with her car, with stocks and bonds, with mutual funds, with furniture, pretty almost anything you can think of that you could own, your trust could own. And the reason it is an important part of any trust planning is because that's how we avoid probate. So the probate laws we were talking about before apply to assets that were owned by a person who died. So if you die and you do not own your assets, your trust owns your assets, then all those rules about probate do not apply. Follow me? And so what happens when a person dies and they had transferred all of their assets to a revocable trust? Well, Lou was her own trustee when she signed on to the contract, but one of the things the contract said was, if I resign or become incapacitated or die, I choose the following person to be trustee after me. So she takes control, decides who is going to be the next trustee. Very often is a family member, as long as it's someone responsible. And that family member, after Lou's death in our example, their job is to pick up the trust contract, read it, and do what it says. And if what it says is pay all of Lou's bills and take the rest and divide it equally between these three people, then that's what happens. This person, this trustee, does not go to court, does not pay filing fees, does not get a bond, does not wait 6 months to a year, does not see a judge, skips all of that probate stuff and just follows the private contract. If it only takes them 60 days to accomplish their task, so be it. That's why people like trusts. So there are more reasons to use a trust. So we're still, believe it or not, on question 5, which is, what is a trust? I think we've covered that. And do I need one? Well, and there you've got an article in your booklet there, which talks about the top 5 reasons why people in New Hampshire like to use revocable trusts. I've already covered the first one, probate avoidance. That's probably the most common reason. The second reason is what I call beneficiaries with special circumstances. So if you want to leave an inheritance or a piece of an inheritance to somebody, but you're worried that they're either going to blow all the money, you don't like their spouse, they're only 10 years old, if there's some special circumstance where it doesn't make sense to give this person a pile of money, a trust can solve that problem really well. Because a trust allows you to say, divide it up between these three people, but this one person over here, don't give them their money right away. Instead, I'm going to ask the trustee to hang on to that person's money for a while. Manage it for that person. For example, if we're talking about a minor child, maybe use it to pay for their college education, but don't give it to them until they're 25, because Lord knows children who are under the age of 25 don't know what to do with money yet, right? So you can do those kinds of things in a trust where you set parameters around the recipient and their inheritance. If you tried to do that in a will, you would cause an ongoing court proceeding with a judge involved. If you wrote something like that in a will, the judge is going to want to follow up. You're going to have to file something. You're going to have to prove that it was done the right way. So trying to do that in a will creates extra time, work, process, money. Doing it in a trust as a private contract is a much simpler proposition. So people who have disabled beneficiaries, that's another big one. There are great trusts called special needs trusts that can be created for the benefit of these folks. And then just people, again, who, if you're concerned about divorce, if you're concerned about not being good with money, or minor children is another significant one. You don't want to just leave money to minors, okay? So top 5 reasons to have a trust. Number 1, probate avoidance. Number 2, beneficiaries with special circumstances. Number 3, planning for your own disability. So a trust is a document that, so we're going to come back to Lou. She thought she was only volunteering for 2 seconds, but we're going to talk to Lou a lot. Thank you, Lou. So, in Lou's case, the trust is not designed just to direct where her assets go after death. Her trust also says, gee, while Lou is alive, this is what should happen to the assets. And first of all, it's going to say, use the assets as Lou says so, because she's in charge. But then it's also going to say, if Lou ever becomes incapacitated, then her next named trustee can step in and manage all of those trust assets for her benefit under, again, this one contractual document that she's created. So it's a really organized, nice way to allow somebody else to step in and manage things for you. Can we do questions at the end?
No.
Thank you. I'm sorry. So the 4th reason why people like to do trusts in New Hampshire is privacy. So believe it or not, wills are not private documents. So if a person dies, they submit their will to probate, that becomes a public record. We can go over to the probate court and read all the wills we want. Some of them are kind of interesting. A lot of people don't like that, especially sort of New Hampshire Yankee kind of, I'm a New Hampshire native, I told you. So do we really want our wills out there as public records? Maybe not. A trust is not like that. A trust does not get filed. It does not become a public record. It is a private contract and stays that way. So people like that. The last thing, and I will point out that this is the only thing on our top 5 list that has anything to do with net worth. Okay, so some people say, well, they really have enough money to have a trust. It has nothing to do with money. It has to do with whether you want to avoid probate, whether you have beneficiaries with special circumstances, if you're interested in privacy, how you feel about planning for your incapacity. None of those things have to do with how much money you have. The 5th thing on our list does. Tax planning, and we'll talk a little bit about that, but not too much. Right now, the estate tax does not affect very many people. You have to have, as a single person, you have to have over $11.7 million to worry about it. But if you do, or if you're married and you have twice that, there are special trusts you can create to minimize the taxes. Okay. So we are going to move on to question number 6 on our top 10 list. The question is, do a will and a trust cover all of my assets? The answer is no. You probably want me to say more than that. So no, a will and a trust do not cover all of your assets. So go back to the beginning when we were talking about how do I construct my estate plan. One of the first steps was to organize yourself. And I said, you got to figure out how you own this thing. Do you own it jointly? Is there a beneficiary attached to this? What is this thing? And the reason that's an important part of any estate plan is because some assets don't pass under a will or even a trust. So when you own assets jointly with somebody, it is very important to understand that upon your death, that asset passes automatically to the surviving joint owner. That happens by operation of law. It does not matter what your will says. It doesn't matter if you have a trust. The only thing that matters is how is that asset titled? If it's titled jointly, then at your death, it goes to that person, period. This is a big mistake I see a lot of parents make as they get older. They say, oh, Tina, I just added my daughter's name to my bank account because she lives close by. I want to make sure she can help me. And I say, go to the bank after you leave here today and undo that. Why? Because number one, it thwarts your estate plan. So if the person I'm talking to has 3 children, she probably intends to benefit all 3 of her children equally. But if she adds one child's name to a bank account, she will not benefit all 3 children equally because that will go only to the surviving joint owner, that one child, who is not required by law to share it and won't. Okay? So the other problem with owning joint property with someone who is not your spouse is creditors. Joint ownership is joint ownership for all purposes. So in my example, if this person had added her child's name to a joint bank account, if that child gets divorced, gets sued, goes through a bankruptcy, or has any other creditor problem, mom can lose her bank account because it belongs to both of them for all purposes. So it is fairly disastrous to own assets jointly with someone who is not your spouse, and can thwart your estate plan. So that the jointly owned assets are going to pass outside of your will and your trust to the surviving joint owner, okay? Another category that's important to understand are assets that carry beneficiary designations. So I'm talking about assets like life insurance and retirement accounts. When you purchase life insurance or you sign up for a retirement account, you are asked to fill out a beneficiary designation form. And if you die, that is what happens to that asset. It does not pass through your will. It does not pass through your trust. It passes to whoever is listed on file as the beneficiary with the company that holds the asset. It is not enough to construct your estate plan with documents. You have to think about how are the assets titled? Does this make sense? And who are the beneficiaries of my assets like life insurance and retirement accounts? And does that make sense? Sometimes you might want to name a trust as a beneficiary. You want to get advice about that. There are some tax issues. But sometimes you name a trust, sometimes you name people, but it's always true that you got to pay attention to that separately from your documents. Okay. So we are on question 7. Will my estate be taxed upon my death? Very unlikely is the answer currently. So the first thing to understand is that at the state level, there is no estate or inheritance tax. The state of New Hampshire does not receive any money for anything when somebody dies, okay? No tax there. The only potential for a New Hampshire resident in terms of paying estate tax is at the federal level. I've already given away the big punchline, 11.7 million and less, no estate tax. That's per person. So if you're a married couple, we're talking well over 22 million, okay? Before anyone worries about federal estate tax. Now, that number, which is currently 11.7 million, can change and has been known to change. And is actually currently, there's a sunset provision in the current tax law that says if Congress does nothing else, then in 2025, that $11.7 million exemption will drop back to the levels that it was before the other law, about 6 million in 2025, unless something changes. So it'll be cut in approximately half. Congress is talking about making changes to that. We do not know what will happen. That's one of those things you have to keep an eye on. I would say the so-called experts, whoever they are, will tell you that is unlikely that that state tax exemption is going to drop below 5 million anytime soon. But who knows? They've been wrong before, right? So a couple other things about taxes. Beware of estate taxes in other states, not New Hampshire. So again, we have this lovely system of different laws in different states, different tax laws in different states. Every single state in New England, except New Hampshire, has an estate tax, okay? And if you own real estate, this is sort of a tongue twister. I don't know, I've got a mask, so we'll see. If you own real estate in a state that has an estate tax, you may have to pay that estate tax because real estate is tied to the state where it's located. Make sense? So if you got a lake house in Maine, you might be subject to the Maine estate tax, even as a New Hampshire resident. So you got to be aware of that. So people often say to me, hey, I just got this big inheritance. What does that mean for my taxes? Generally nothing. An inheritance is not subject to income tax. The one exception to that is if you leave someone a retirement account, like an IRA or a 401k, there will be income tax associated with that asset. Because you probably know that for yourself, when you take money out of your retirement account, you do what? Pay tax on the money you take out, right? Because that's a tax deferred asset. It's not tax free forever. It's taxed when the money comes out. So if you die and you leave that asset to a beneficiary or beneficiaries, when they take the money out, they pay income tax on those assets, okay? So those are the only real tax issues to be too concerned about. Question number 8 on our top 10 list. How often should I update my estate plan? The rule of thumb in our office is 5 years. Doesn't mean you have to redo your whole plan every 5 years, but I think it's worth your while to at least take out your documents, look at them, think about them every 5 years or so, and see if there's something you want to change. Major changes in your life, like marriages, divorces, births, things like that, could cause a need to update your estate plan. Changes, with children or grandchildren as they grow, develop different needs, situations, those things can affect your estate plan. Changes in your wealth can affect your estate plan. If you hit, more than 11.7 million, you're going to want to do some tax planning. So those things can affect you. Moving to another state, it should come as no surprise, affects your estate plan. So if you created a New Hampshire will and it was validly signed here in New Hampshire, it's going to be accepted anywhere in the country. However, laws in different states are different. And so that will might not work nearly as well as it would work here. So if you move to a different state, you always want to make sure that you connect with a lawyer in your new state, have them at least review your documents. Chances are very high they're going to have some recommendations for improvement. Okay? So those are reasons to update your estate plan. Question number 9. How much can I give away to my children during my lifetime? Gifting, lifetime gifting is a common question. I'm going to tell you 2 rules, and then you can forget about one of them, okay? I'm going to tell you about the tax rule. That's the one you can forget. And then I'm going to tell you about the Medicaid rule, and that's the one you should worry about, okay? The tax rule is the one everyone knows. The tax rule says that I can give away $15,000 to as many different people as I want in a given year without paying gift tax, right? So I can give $15,000 to you, $15,000 to you. This is not going to happen, by the way. This is not making, no promises being made here. But I give $15,000 to you, $15,000 to you, $15,000 to you. What happens if I get to Lou and I say, Lou was my star volunteer? I want to give her more than $15,000 because she was so great. I'm going to give Lou $20,000. What happens then? The answer is not much. What happens if I give Lou $20,000 is that what I have done is I have used up $5,000 of my lifetime credit. Anyone know what my lifetime credit is? It's that $11.7 million number I told you about. So that $11.7 million number, we talk about it in terms of the estate, but it's actually a lifetime gift and estate exemption. So as long as you don't give away $11.7 million to anybody, nobody's paying gift tax, okay? So I can give away, so if I gave Lou the $20,000, I have to file an informational gift tax return with the IRS saying, hey, IRS, I've used up an itty bitty piece of my $11 million credit. They're going to be like, yeah, we don't care. So that's the rule that the vast majority of people can just forget about. So give people 15,000, give them 16,000. It's not a big deal. No one's paying tax. The bigger deal is the Medicaid rule. Okay, so have people heard about the 5-year look back? Am I seeing some nods? No. Okay. So I promise we will come back to the point, but this is going to require just a little bit of information so we can all get to the same place. Okay. So this has to do with nursing homes. So if a person requires nursing home care, nursing homes are expensive. Yes. So the question quickly becomes, how do I pay for this? And so you can either private pay out of your pocket. You can pay with long-term care insurance, which is a special kind of insurance that most people do not have because it's expensive. Or you can use Medicaid. Medicaid is a welfare program. It is not the same as Medicare, C-A-R-E. Medicaid is a welfare program. If you want welfare to pay your nursing home expenses, you have to apply and demonstrate that you are poor. The 5-year look back is a question on a Medicaid application. It says, okay, you're poor. In the last 5 years, have you given assets away to anybody? If you have to answer yes to that question, the response will be, okay, well, because of the gift that you made, you artificially impoverished yourself and you are disqualified from receiving welfare benefits for a period of time, depending on the value of the gift. Right now, and the law, this amount changes, but right now, about a $10,000 gift is going to result in about a month of disqualification. Is there a $15,000 safe harbor? No. So that rule, that gift tax rule I told you to forget about, that does not help you. If you say, oh, I was only giving $15,000 away per person, Medicaid doesn't care. If you've given gifts, you may not be a recipient of welfare. So it's important. It would be great to have a crystal ball so that you know, am I going to need nursing home care and Medicaid benefits in the next 5 years? If so, I should not make gifts. It's hard to know that. So as people get older, it becomes riskier, frankly, to make large gifts to other people, because if you land in a nursing home and need help at some point in the future, that gift could come back to bite you. Okay. We're going to do question number 10, and then I will take some questions. Question number 10 is, okay, Tina, now we're depressed. How do we protect our assets from a nursing home? Well, I'm sorry to tell you that there is no magic bullet, okay? Long-term care insurance is one option. That is a special kind of insurance that you purchase in order to pay for nursing home expenses if you need them. But the optimal time to shop for long-term care insurance is when you are in your 50s. Once you get beyond that, it, for most people, is too expensive. A lot of times people will consider irrevocable trusts for this purpose of protecting their assets from a nursing home. I do not recommend that. And the reason I do not recommend that is because they can be very problematic. When a person goes to apply for welfare benefits, they would have to present that trust to the state, which is administering the application. And the state's going to work really, really hard to poke a hole in that trust, because they don't like the idea of a welfare recipient having a trust with some money in it. And they're going to try to get it. And they often do. So I find them to be fairly ineffective and too restrictive for the individual during life. Because when we talk about the grantor and the trustee and the beneficiary, those 3 parties to the trust contract, the kind of contract that you would have to create to protect your assets from a nursing home would not allow you, Lou, to be your own beneficiary. That's a big deal. What those kind of trusts say is that Lou can receive the income from her trust, but she could never again have the principal. So that means if Lou had a stock account in her irrevocable Medicaid planning trust, she would be entitled to use the dividends, but she could never have the stock. She couldn't sell the stock. She couldn't have the proceeds. That would no longer belong to her. I think that's giving up too much. You might as well have made a gift, because you're really not benefiting enough from your own assets at that point. So what I would say in terms of how to protect your assets from a nursing home is to be really informed. And this is beyond the scope of today's talk because these rules are incredibly complex and they're very person specific. So if you ever find yourself in a situation, there are things that you can do to improve your situation. You want to talk to a lawyer or somebody else about your particular situation and what can be done. There are built-in rules in place that protect spouses. So, the law recognizes, hey, if one spouse needs nursing home care, we don't want the other spouse left out destitute on the street. So believe it or not, in that situation, the spouse gets to keep the home, period. There can't be a lien on it. They can't make them sell it. So there's all sorts of protections for a spouse who continues to live at home. And that can provide people with a lot of comfort because that's usually the biggest concern people have about the nursing home scenario. We have gotten through our top 10 questions. I will now open it up. We have only about 10 minutes, but we'll take what we can. And I'm happy to stay afterward if people feel they'd like to and haven't gotten their question answered. So you had a question earlier. You get to go first.
Right after, well, back to the trust, is it easier to amend trust language as opposed to the will language? Let's say you have a dependent who then becomes someone you don't want to give a lot of money to. Is it easier to do that within a trust, or doesn't it make any real difference?
So the question is it easier to amend a trust than it is to amend a will? I would say most people don't amend wills. I would say when people want to make a change to their will, we just do a new will. But I wouldn't say that's necessarily harder. It's just a difference. With a trust is usually, a 15 to 20 page legal document. So you wouldn't necessarily restate the whole thing unless you're making a lot of changes. A will is usually a 6-page document. So if we're going to make a change to the will, we're just going to do a new will because it's just as easy. Does that answer your question?
Yes.
Okay. What other questions? Yes.
If you have all of your advanced directives done, but they were done before these various laws came, are they still valid, or do you need to run, not walk to your state planner,
Yeah.
or can it wait to your next usual review?
Yeah, it's a great question. So the question is, if I've got my advanced directives done in place already, and we've heard about these new law changes, 2018 for the financial document, 2021 for the healthcare, is it super important that I update? Your documents are still valid. There's nothing invalid about the old documents. My view is more, the next time you're doing your review, you want the new form. And the reason you want the new form is that eventually the medical providers and the financial institutions are going to be used to the new form. And you don't want to be the one that has the old one because it's going to be harder for your family to use it. It is not an emergency, but it is a good idea to do it at some point. You want to do that update. Does that answer your question? If somebody on Zoom wants to unmute and ask a question, I don't mean to ignore you guys, so you can. I'm going to try, I only have 2 eyes, so I'm going to try to monitor both. Is there someone on Zoom who wants to ask a question right now? We'll sort of alternate. How about that? Joan, you want to unmute? So Joan, you're still on mute. So there's a little microphone button on the bottom of your screen. And if you click on it, right now, it looks like a microphone. It's red. There you go.
So now you can hear me now?
I can hear you now.
Okay, great. I'm hard of hearing, so I think I missed something. And that is when you were talking right out in the beginning, you were talking about, I think he was a Judge Fairchild.
Judge Fairbanks, yeah.
Fairbanks, okay, Fairbanks. And, okay, how does requiring an executor to be bonded protect one from an unscrupulous judge?
Oh, that's a great question. So Joan was asking about my Judge Fairbanks story and how does a bond protect somebody from an unscrupulous judge? It turned out, Joan, Judge Fairbanks was the executor in those cases. That doesn't happen a lot now, but it did then. So he was the executor. That's how he absconded with the money. If he had had a bond, they would have reimbursed the estate.
Yeah, okay.
All right, we're going to take a live question now. So we're going to alternate. I'll come back to you, Zoom, so be ready.
Yeah.
You had a question, yes.
Is a living will and a DNR the same thing?
That's a great question. Is a living will and a DNR the same thing? No, they're extraordinarily different. A living will is a document that is within the New Hampshire Advanced Directive that I described to you. And it is intended to give guidance to your healthcare agent, the person who may need to make medical decisions for you about what your wishes might be. It is not directing anybody to do anything. And in fact, the person you select as your healthcare agent can ignore your living will if they want to. You hope they won't, that you hope that they'll read your living will and abide by your wishes as you've laid them out, but it's really just a guidance document in New Hampshire. A do not resuscitate order is a document you would only sign with a doctor. You would never sign a DNR in your lawyer's office. That doesn't happen. A do not resuscitate order is an order that your doctor issues saying this person has reached a point in their life where they're terminal or they've got some other situation where if they have a heart attack or stop breathing, they don't want to be resuscitated. The doctor issues that order, makes that part of your medical record. People put it on their fridge in hopes that if there's an EMT that sees it, they would abide by it. But that's a very different story than the living will, which provides guidance to your agent about your end of life wishes. Does that answer your question? Okay. All right, Zoom. Who on Zoom wants to ask a question?
You're all good with muting and unmuting?
I think what's good. I think,
All right.
but thank you, Susan. I appreciate it.
This is Melissa McAllister. Can you hear me?
Yes, go ahead, Melissa.
Hi. Hi. I'm here for myself, but also my parents, who are 85 and 87. They live in Massachusetts.
Yeah.
And so my question is twofold. One, when they create a trust, do they create it together? Is my first question.
Okay, so the answer to that is it depends, which by the way,
Okay.
every lawyer's favorite answer to every question is applicable in all cases. The answer is it depends. It depends on a couple of things. Primarily, it depends on Massachusetts law. So I'm a New Hampshire lawyer. I don't know would be recommended in Massachusetts. But generally speaking, like here in New Hampshire, a married couple have the option of having a joint trust that they both sign on to, or two separate trusts. And when we have a married couple in front of us, we always discuss those options and what makes sense for them. So it depends.
Okay. And then my mother has it in her mind that, oh, it's too late. You know, we're 85 and 87. It's supposed, you know, if we have to go to a nursing home, they're going to take it anyways for up to 5 years. She's got this up to 5 years in her head.
So has everyone heard the question? So the mom's concerned that she's 87 and that it might be too late to do any sort of Medicaid planning. Again, Massachusetts law is going to be different. So I really wouldn't be able to say. Generally speaking, it's pretty tough for an 87-year-old to come up with a reasonable Medicaid plan. She's not entirely wrong. The 5-year look back is the gifting issue that we described. So the problem is if an 87-year-old makes a gift, she's got to make it 5 years without needing Medicaid benefits in order to clear that gift, so it's not a problem. So it is absolutely the case that the older you are, the more problematic a gift can potentially become.
But if she hasn't gifted anything in the past 5 years.
So if she hasn't gifted anything in the past 5 years, but what is she trying to do in terms of a Medicaid plan? So she wants to make a gift now, right? To get assets out of her estate so that it goes to her kids instead of to a nursing home. Right?
Yeah, I think I'm lost. So I think I'm lost. So is the gift, so like.
So what is it she wants to do? What is it you think she should do now to protect her assets from a nursing home?
I just think that they should have a trust in general.
The ordinary trust, the kind of trust that we were talking about when we were describing what Lou had, hi Lou, is not an asset protection trust. It's not a Medicaid protection trust.
Mm-hmm.
The only kind of trust that would protect assets potentially from a nursing home, first of all, has to be irrevocable. That's the first strike against it. The second thing is that type of trust would not allow you to be your own beneficiary. So you're basically giving up your rights to the ownership of whatever the asset is. And the third problem, and they may be friendlier in Massachusetts, you need to talk to a Massachusetts lawyer about this, but at least in New Hampshire, the state Medicaid office is pretty unfriendly when it comes to Medicaid asset protection trusts. They don't like it. They will fight you every step of the way. They will very often get money out of the trust. So Massachusetts law is what your mom needs to focus on as a Massachusetts resident. So I'd really recommend talking to a lawyer there about those specific issues. Does that help?
But if they don't end up in a nursing home, it allows the person that they've named to be able to pay off their bills and that sort of thing.
So you got to talk to a lawyer in Massachusetts.
Massachusetts, yeah.
So everything I've described today is New Hampshire law. So my vague understanding is that it would work similarly in Massachusetts, but you would really want to talk to a Massachusetts lawyer to confirm what are your mother's goals? Will a trust accomplish those goals?
Gotcha. Okay, thank you.
All right, we are over our time. So I do want to be respectful of everyone's time. So if you need to go, it was wonderful to see you all. You have been an excellent, super smart, very attentive audience, my very favorite kind. I so much appreciate it. My next program will be here on November 15th at 3 p.m. That is the first of a two-part series. Part 1 is understanding wills. So I said we would be delving into a little more detail on these topics. So we'll be delving into that. That one's kind of fun. I do it as kind of a storytelling exercise where I tell you about all the awful things that have happened to my clients so you don't let it happen to you. And then the second in the two-part series is on December 1st at 1 p.m. and that one's called Understanding Trusts. So I'd love to see some people back for those so I'm not here alone. That'd be great. Thank you so much. Like I said, I'm going to stick around. If people have additional questions, I'm happy to be here for that.
Thank you.
You're welcome. Thanks. So is there a question right here? Oh, the November 15 is 3 o'clock and the December 1 is at 1 o'clock. Yeah, but
Call your office if you want to set up. I had a will done 10 years ago, but
Yep.
I'm feeling like it must be worth it.
so my card is in the packet, so feel free to call the office. Yeah. For the programs called Good Life to register. Yeah. Question.
The person has a trust, a revocable trust, and they funded it with all their assets, or their assets have beneficiaries. But they don't have a will, and they die. In New Hampshire, does the trust control or does the testacy law?
So the trust controls any assets that are owned by the trust, always. It is rare that a person would have a trust and not a will. The vast majority of people who have a trust also have a will. The will says, I leave everything to my trust. That's done as a stopgap in case you forget to put something in your trust while you're living. You have a will there to catch it and put it where it belongs. So most people do have a will, but the intestacy law is never going to apply to an asset owned by a trust. Yeah. Any questions on Zoom? Speak up.
I have a question.
Yeah.
The packet that you're talking about, can the people in Zoom get access to that as well?
Yes, I plan to send you an email. I don't know if it will be today, but maybe tomorrow with everything that everybody here received. So yes.
Awesome. Thank you very much.
Good question. You're welcome. Somebody else here? Questions? Yeah.
So if you were to give a annuity to someone, child, as opposed to, so the gift is the annuity. Then if you were to end up in the Medicare situation, the clawback or the adjustment is up against you with your remaining money, right? They would say you're not broke.
Not necessarily. So New Hampshire has a very nasty law that says if a person is in a nursing home and can't pay because of gifts they've made, the nursing home can go after the recipient.
Even though it's in
collect.
the form of annuity.
Yep.
Only pays them a monthly fee.
They don't care about the form. They're going to say, that was a $300,000 gift. You need to give us the $300,000 or you're not on Medicaid. And if you're not on Medicaid, there's going to be a nursing home bill. And the amount of the bill is what they would go to collect from the recipient.
Okay.
Yeah.
So if you held enough money back to pay the nursing home bill, you would be okay.
Sure.
Annuity.
Right, but that's very expensive, right?
Yeah, well, it's 10,000 a month. but-
Yep.
But that's only for 5 years, so if you're into it for 3, it'd be only $240,000. It wouldn't be-
Only.
Well, yeah, but it wouldn't be,
Uh-huh.
the annuity would be. more
Right, you
expensive.
always have to look at those numbers change, right? So you wouldn't want to rely on knowing what the numbers are going to be.
Mhm.
The other piece that may change is right now we have a 5-year look back, but it used to be 3 years. There has been talk of making it 10 years. So that's another piece that's a wild card that we can't for sure anticipate. Yeah. Was there a question on Zoom? No, everybody there's.
Yes, I have a question. another one.
Yes, Joan, what's up?
Could I own a house with my brother as if we were a spouse. In other words, whatever that's called in tenancy or in joint or whatever.
Can you? Yes. Should you? No.
Okay.
I mean, the risk to you in owning a house with your brother is if your brother gets sued, goes through a bankruptcy, gets divorced, or has a medical condition, your house is in trouble because he's an owner and you're an owner. Whatever happens to him happens to your house.
Got it.
Very risky.
Got it.
Yeah.
Okay.
Live questions? Yes?
I know you don't recommend this, but if the person did have a irrevocable trust, specifically for Medicaid claim, does the date of the trust also figure in the 5-year look back? If the trust, those assets are gone.
So the question is, if you do have an irrevocable trust, which I don't recommend, is it the date of the trust that matters for purposes of the 5-year look back?
Well, in other words, if I did that tomorrow, and then I have to, is the 5-year look back say, hey, your trust was within 5 years, so you gave the stuff away within 5 years?
No, the date that is applicable is the date that the asset was transferred to the trust. So if you created the trust on January 1st, we didn't put an asset in until August 1st. August 1st is the date that you made a gift to the trust. That is when the 5 years starts ticking. If you put another asset in a year later, you start the 5 years ticking. So every transfer to an irrevocable trust is the same thing as making a gift. It starts the 5-year clock running. People on Zoom, anybody?
I have a question.
Yes.
If I had a trust made by a different lawyer, if later I wanted it to be reviewed and maybe updated with a new lawyer, is that okay?
The question is, if she had one lawyer prepare a trust or other documents, is it okay to switch lawyers? Absolutely. It happens all the time. You just contact the new lawyer. You probably contact the old lawyer because often lawyers keep the originals. So you just want to request that they be transferred. Happens every day. Very easy.
Okay.
Yep. Any questions from our live program people? Do I have a set fee? I do not. I charge hourly. So, every plan I do is customized. My current rate is $300 an hour. I do it enough that I'm pretty good about giving people estimates, at least with a range of what I think a project will cost before we decide to do it. That's how I handle it. Somebody on Zoom have a question? Everybody's all zoomed out? Okay, going once, going twice? Anybody in the live program with questions?
I have a question.
Oh, yes, Joan.
Well, for the simpler, let's put it this way, how much does a trust cost? And of course, you can't answer that because they can be complicated, but what would you estimate as simplest? Where does it start?
I would say, so it is a very difficult question to answer, Joan. And so the best I can do is to give you a really big range. I would say most estate plans that I do for people fall anywhere between $800 and $5,000. There's a lot in between, and it very much depends on what the person is looking to do.
Okay.
I wish I could be more specific, but that's all I got.
No, but yeah, that's good enough. I get it.
Great.
Thank you.
One more question.
One more. This is the last one. Go ahead. Make it
Is life insurance protected from nursing homes?
That's a good question. Is life insurance protected from nursing homes? Generally, no. Generally, nursing homes. So I think there's a lot of misconception about, protecting things from nursing homes. A nursing home is a creditor just like any other creditor. And so if you need nursing home services, they expect to be paid for their services. Their services are expensive, which makes them feel unique because people will spend their entire life savings paying these nursing home bills. Nursing homes don't have any special power to take anything. They're just creditors who need to be paid. When a person gets to a situation where they've spent a significant number of assets and they're looking for help, they might apply for welfare. So the rules about qualifying for welfare benefits is where people start to say, well, You can't be on welfare if you've got life insurance that's worth over X dollars. You can't be on welfare if you've got, a second home in Maine. So that's where the rules come in, because they're sort of welfare eligibility rules. There's nothing magical about a nursing home. They don't take people's houses. They just expect to be paid for their services. Does that make sense?
Yeah, it's just that you want to have some life insurance money left over for your burial.
Yes, well, actually, that's a great question, Cheryl. So the Medicaid rules, which are the rules that restrict things, these welfare rules allow you to have an irrevocable prepaid funeral contract. So they say, yes, you can be on welfare and have a burial fund. It's not always in the form of life insurance. You have to make sure it's set up so it's irrevocable, so you can't get the money back, because they're saying, well, gee, you can be on welfare, but you're not going to use your life insurance or your burial program as a savings account that you can get later. So you have to prove to them that it really is a fund to pay for your funeral, but the welfare office will allow you to be on welfare and have a burial contract. They won't let you have a $250,000 life insurance policy and be on welfare.
5,000?
There's a rule right now, and this changes, Cheryl, so don't quote me on it, but I think the limit right now is like 1,500. So you would have to cash in or redo or something like that.
So where do you get that contract?
The life insurance contract or the burial contract?
The burial.
You contact a funeral home. Funeral homes do those.
Oh,
Yep. Okay, well, thank you everyone again. I appreciate those who stayed late. I'm always happy to chat, and hope to see you guys at the next program.
thank you.
You're welcome. Have a great rest of your day.
Thank you.
Thanks, everybody.
So I'm going to leave the folders here.